Anyway, since we seem to be out of witnesses, I thought I'd drink a little.
Afternoon. Happy Friday afternoon, Tyler.
Happy Friday. We've moved our taping back to Fridays, or at least this week we have.
Yeah, it's because we've been occupied and you've been in some stressful litigation this week, and so we moved back to Friday, but we may be.
There we go.
I do have a gin and tonic.
Ah, very nice. I've got my my whiskey sour again. This is my go-to the past little while, these hot summer days.
I like to mix it up a little bit. I thought about a beer. I had some St. Tao in the fridge, but all of a sudden a gin tonic struck me as delightful. So that's what we have.
Our other business partner likes a good gin and tonic. That was his go-to for a long time.
We should invite him on here sometime. Get his take on this straight law cocktail.
All right, but he can't be boring. We got to get him animated a little bit.
So we're going to talk today about your week. You had a stressful week trying to help out a client. I understand. Is that correct?
Yeah, it was a little bit stressful. Funny thing is, there isn't even a lawyer on the other side. The stress was, I would say, the administration of our justice system was really stressful. A barrier that ought not be there. Not only is it inconvenient, it actually shouldn't be there. That's the problem.
So I put out a little teaser yesterday.
Oh.
I knew we were going to talk about this. And on my Twitter, I asked a couple questions to the Twitter sphere. Does COVID absolve the system from being required to be open? Because that was part of your issue, as I understand.
Yeah. Let me explain the problem or the issue, and then we can dissect that. That's good. So I had a client show up Monday afternoon and say, look, he thinks that there's this court order that was granted without him having any notice that says the child that he takes care of and has been the essentially only caregiver of and who has some pretty severe medical issues was to be taken out of his care and put into mom's care. And he explained to me his concerns that that could be very detrimental for the child, considering the child's needs and the mom's lack of resources, let's say. So this was pretty concerning that a court would give a court order without any notice that would change the primary care of the child, like I say, without any notice. That's kind of fundamental to our system, is that you need to know the case against you, or at least know a case is against you.
So let me unpack this a little bit,
Sure.
just to make it clear to anyone who's listening. So there was an order granted, what we call ex parte, which means without notice to the other person, right?
Right.
And now, basically every ex parte order I've ever received or had served upon my clients have included a requirement that they serve, along with the order, the application and the affidavit that would give you some sense of why the order was granted. I'm assuming the order provided that your client was at least given the application and the evidence upon which the application was made. Is that the case?
Not only were we not given the application or affidavit when I requested it from the courthouse, I was told to fill out a form and they would get it to me in 10 to 14 days.
Okay.
I did fill out that form 3 or 4 days ago. I explained that it was an emergency. Still haven't got it. We still don't know. Nothing.
So an order is made that, at least according to your client, put a young child at risk of serious harm, and he wasn't even given a copy of the application along with the order.
Nothing.
Interesting.
Yeah.
Horrible. So now did the order give him some opportunity to bring it back before a judge immediately if it was found to be without basis? Or
No, there was a review date, let's see, 2 weeks later.
so
So that's problematic. So then he comes to me and I think, well, I better do something about this, right?
okay.
So what I do is I get a hold of the clerks at the Provincial Court in Calgary and I say, look, we got a bit of an issue here. This order was granted. We got some serious concerns about it. And we need to talk to a judge about it. And they said, look
So
here. Oh, sorry, go
I'm
ahead.
assuming they said, well, that's fine, we'll get back to you and we'll get a judge to speak to you, within 24 hours or something like that. Is that kind of what they did?
They said to me, look, you're going to have to get an application before the court, which, hey, fair enough. But all the lists are full and you're probably not going to get in before August 31st in any event.
Okay, and this is a direct sort of result of the COVID restrictions. Is that your sense of thing?
Yeah, that I don't know. I mean, I know that the lists are pretty full because there's a backlog because there was no court sittings for some time. And I know that Provincial Court family matters are particularly backed up. And so, yeah, I get that there's some issues with that. My concern is we got somebody who's not a lawyer who was able to get a court order in one day without any notice to the other party. And then we got me, the lawyer, who can't even get a judge to listen to me in 1 day or 2 days, or actually 3 days is what it turned into. Yeah, couldn't even get a judge to listen to me on it.
So in the day, if it were me, you could walk into provincial court during a docket day and express to a judge that you have this problem if you couldn't actually go see a judge. We don't have open courts like that right now due to COVID. Is that correct?
It's sort of correct. So in Calgary, I think that they do have some people who are physically in the courtroom, and there is a judge and there is a clerk in the physical courtroom, and then there's a few lawyers or parties in the courtroom. It's discouraged. They don't want you to be in the courtroom. They want you to appear virtually.
Because down here in Queen's Bench, my applications have all been virtual. You're on Zoom or WebEx, actually.
Yeah. And for the most part, the judges aren't actually sitting in that physical courtroom. You're right. Yeah. So typically it's not the case. But Provincial Court Calgary, they are actually in the courtroom with a clerk, and there's a few parties there.
This kind of raises the issue that was in my tweet earlier about whether COVID means justice is no longer open. And the general concept is, I've been doing this 34 years, is justice has to be open to public scrutiny. With very few exceptions, the courtroom is an open place where the public is entitled to go see what's going on, even if they're not directly involved. Now, there's some child welfare, adoption, some limited criminal matters, but for the most part, general litigation, including family litigation, is open court. So they, as I understand, Tyler, well, maybe tell me where you went, but my understanding is you basically went to court via WebEx to try and speak to a judge when the clerk refused to facilitate you contacting a judge through them. Is that right?
Exactly. Yeah. So I attended court virtually like this. And so I just signed into the courtroom, and then the clerk, there's a little chat box. The clerk said, "What are you doing here? Or do you have a matter?" Which is typical in court. You'd usually go chat with the clerk and they would know what you're there on. And I explained to the clerk, yeah, I've got an emergency application that needs to be heard. There was an ex parte order granted. There's a review date, but unfortunately there's risk of irreparable harm to a child. So I need it reviewed today. And I'm happy to wait until the end of the list and talk to the judge then. The clerk says to me, "Look, we got a full list here and you shouldn't be here. Call the clerk's office and try to arrange something." So I'd already tried, but I thought, let me try again. So I stay in the courtroom, mute my mic, call the clerk's office, and I explained to the clerk, "Look, here's where we're at. I'm in this courtroom. I'm waiting for the judge, but it's an emergency, and that clerk says they're busy, and it's not great. And they'd like me to talk to you and see if I can arrange something. Can you help me arrange something?" And she says to me, "Look, I've heard about you. if you're in that courtroom virtually, you're not supposed to be there. You don't have anything on the list. She says, I would like the name of the managing partner at your law firm so that I can report you because you're acting inappropriately.
Okay, so you're asserting your client's interests,
Which is my duty. Yeah, absolutely.
and they threaten to report you to your partner,
Right.
your managing partner,
Whoever that is.
which
Yeah.
is effectively you, being you're one of 3 partners and we all manage our firm.
Right.
Okay, so what happened then?
Well, I realized this is not getting me anywhere. So I hang up the phone on her. And then my plan is I'll just wait in the courtroom until the judge, till everyone else is gone. And the judge will look at me and say, oh, who are you? What do you want? And so I hang up the phone, look at the screen where I'm in the courtroom, and the clerk boots me out. I get kicked out of the courtroom. That is hugely problematic. Now I've had at least 2 clerks create a complete roadblock for justice. And you know what? The clerks in Lethbridge, fantastic. Both Provincial Court and Court of Queen's Bench. We work together really amicably. We work together to administer justice. And we're not doing it against the public. We're not doing it against anyone's interests. If it's a lawyer on the other side, we work with them. If it's a self-represented litigant on the other side, guaranteed we're working with them. But in Calgary, in Provincial Court, in the matter of 2-3 days, I had these 2 clerks at least create a complete roadblock for me to access any sort of justice, where we've got a risk of irreparable harm to a very young child, and and I get kicked out of a courtroom. I'm a lawyer and I got kicked out of a courtroom. It's completely unacceptable.
And in fairness, I mean, you are proceeding based on the evidence from your client as to the state of affairs.
Yeah.
Presumably the mother has a slightly different perspective.
Right.
But at least in theory, you have a situation where a child's life could be at risk. And you are seeking to at least have an audience with the court before that order is enforced. And basically you're stymied.
Yeah. Now, if I have a judge tell me, you don't have a case, I'm not going to hear it, blah, 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 whatever. If a judge is going to shut it down, you know what? That's what it is. That's a system. There's a whole system set up for that. If I don't like what that judge said, I can try to appeal it to a higher judge. Don't want what that judge says, you can appeal it. There's an appeal system, right? When a clerk, when the coordinator, when the administrator, when the staff just kicks me out of the courtroom, what am I left with? What's the procedure? What's the process? What do you do?
And the thing that struck me when you brought this to my attention, and you were a little more frustrated then than you are now, and we'll get into where things went from there. But
Sure.
The thing that struck me, and I mentioned it on my tweet because I think it is relevant. Your client was an Aboriginal person, and my experience has been marginalized people generally, but in particular in Canada, Aboriginal people, they struggle with how to deal with authority and courts and police. And so the thing that struck me was, without your assistance, there's no chance in hell that this gentleman is going to be able to stand up to the inertia of this behemoth system that doesn't seem to have any capacity or check and balance in an immediate sense to what could have been a very problematic order. Is that fair to say?
Yeah, I mean, that's completely fair to say. I've had, we live in Lethbridge, right? And so we do have lots of Aboriginal clients, and you know what? That's a particular thing we need to pay attention to. It's important when you have an Aboriginal client to pay attention to that, because we are operating in a system that they haven't operated in or don't always operate in, and culturally and historically, it's a different system than what they are used to, and it's very important. I mean, I don't know that any client would have been able to find any resolution. So it was tough.
And then beyond that, you indicated, well, it's not even that a judge dismissed your application. It's not even, for that matter, that a judge said, you have no business in this virtual courtroom, Mr. Pollock. You need to leave.
And if that happened, I'd take issue with it still. If a judge said, I'm not even going to listen to you, I got a bit of a problem. But when I don't even get that far, when I have an administrative staff saying, here you go, you're out of here.
And this is what strikes me. And this is what, sometimes I bitch about this stuff. And 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 I should be fair. My mother is a former administrator at family court in Lethbridge, Provincial Court. And I know many of the clerks on a personal basis. Their job is not easy.
Oh, for sure.
The administration of justice is a complex animal. But one of my big bitches is that the system exists to make the system more easily functional for the administration of the system, not for the people that need the system. And this is perhaps one of the worst examples I've seen in a long time of that example, which is, this is inconvenient for the administration. We have too many matters on today. So if a child is injured or, suffers harm because you can't have some opportunity to question an ex parte order, oh well, as long as the clerks in Calgary aren't put out. And I find that so fundamentally offensive. And it's such a struggle. I've dealt with the self-represented litigants program in Canada. And over and over and over again, we deal with parties that say, it just seems like the system is designed to prevent you from getting justice. And I don't agree with that. That's not what it's designed to do, but it's the effect in many cases that that's what it does. And in this case, at least at the initial steps, that's what it did. It denied this gentleman an opportunity to say, well, hold on a freaking minute. Am I not entitled to say that there's a problem with this? So let me go beyond that. So clerk throws you out. You've made a valiant effort, Tyler. I'm assuming you called your client and said, I've done what I can do. My apologies for the system. Good luck. Is that kind of what happened, or what happened after that?
No, that's not how we do things. No. So, we got to put a little thought into what to do at that point, right? Because then what do you do? I haven't even been able to talk to a judge. What do you do? And so I kind of rattled my brain, and I think you and I chatted a little bit. And what I needed to do is I needed to get in front of a judge who has jurisdiction to hear this. And so it's a little tricky to figure that out. We've got this order from a judge that we find really offensive. And
clear.
Right.
The judge we found offensive. It's the order we found offensive.
Oh, yes, let's make that very clear. The order we found offensive. So what I did is I filed an appeal of that order, and in the application for an appeal, I asked for a stay. And I did this in the higher court, in the Court of Queen's Bench. And I did it in the proper judicial district, in my opinion, which is in Lethbridge, because the child resides closer to Lethbridge than the Calgary courthouse. And so I did that here, and the court staff in Lethbridge, both in Provincial Court and in the Court of Queen's Bench, were able to functionally assist me in getting in front of a judge, and it's not that they had any bias. They didn't think, oh, Tyler should win or whatever. It was just, oh yeah, Tyler says that this needs to get in front of a judge. Judges make judges' decisions. They got me in front of a judge. And, to be 100% fair, I made sure that the mother who obtained this order without any notice, I made sure that she was able to be in the courtroom virtually as well. She attended via telephone. And then we got to lay it out in front of a higher court judge to make a decision as to, well, what do we do at least until this order gets reviewed in a couple of weeks. So we were successful in having that order stayed, which just means that they're going to stay enforcing it. So the order is not going to be enforced and actually extends until that order expires. So effectively, come the review date, we'll more or less start over and figure out, okay, what is in the best interest of this child.
So on the review date, both the father and the mother are going to have a full opportunity to put their case before a judge and to have a judge make at least an interim decision after hearing both parties fully. Is that more
Yes.
plan now?
I would say more or less. My concern still would be, are we going to be able to see the materials that were relied upon that gave this initial order? Can we see those? Am I ever going to see that? So it'd be nice to see those beforehand. And that's usually part of our system, that we know the case against you. You would know what the deal is. But still to date, I don't have those. We'll see when I get them. Yeah, I was able to order some transcripts from that hearing that, of course, we didn't know about. And I was able to do so without the input or the help of the clerks in Calgary, who basically, as far as I know, my assistant was talking with them. You know, my assistant says, look, I need to know the time. Can you help me figure out when this was there in that courtroom? And they said, no, you have to submit a request and it'll be another 10 to 14 days. And so we were able to narrow it down enough for the transcript company to I think, find them without needing the help of the clerks in Calgary.
So it's interesting because your experience is that some clerks you dealt with were not only unhelpful, but they were obstructive to justice.
Oh, for sure.
And in Lethbridge, clerks were very facilitating, not in you getting your way, but in at least getting you in front of a judge.
That's right. That's exactly right.
Which would seem to be what we ought to be trying to do, wouldn't you think?
Yes, we need to facilitate justice, especially if that's your job, right? Holy cow.
And so that's what struck me, right? So effectively, you know, and to get back to this open court issue, you know, you were in open court. At any time, did you speak up and say, hey, judge, you suck? Say anything offensive or rude? Did you speak at all in the courtroom when you were on WebEx?
Didn't say a word. I used a messenger service on the side to speak with the clerk directly. Didn't interrupt any proceedings. The judge had actually just barely walked in by the time I got kicked out. So. And
the clerk, did you text her and say, you're a terrible human being. Your mother smells of elderberries. Did you do anything offensive or off color in your discussion with the clerk even? Not even a little bit. You know, I think I said earlier what my words were, that, you know, I was there on an emergency matter. There was an ex parte order that was granted to yesterday or the day before, and that I needed to have it reviewed on an emergency basis, and that I had an application prepared. That's all that I said. So it struck me, when, you know, and beyond the prejudice to your client, the idea that effectively you're in a courtroom, which is an open place for the public, and justice needs not only to be done, but needs to be seen to be done. And you're thrown out. You are effectively thrown out of an open courtroom by a judicial clerk without basis. Now, we can back up a hair just to make sure we're being completely fair, or at least that we're trying to be. I know that these WebEx hearings, the court has kind of said, we don't want a bunch of people logging in because there's some issues with that, with microphones and confusion and too many people. And while I get that the administration of that can be difficult, it's really important, and it always has been, that those courtrooms are open to everybody. I've heard a story of a judge, and maybe you know this better than I do, who would insist that the courtroom doors that lead to the hallway of the court wouldn't be shut because justice needs to be seen to be done. So, you know, the fact that you would throw a lawyer out who says, I got an emergency, I got to talk to a judge, is horrendous, just horrendous. People should be welcome. The media should be welcome. You know, that's the media has always been an important kind of check and balance with government systems generally. And that's the thing that strikes me is would it really have been so difficult for the clerk to pass on a message to the judge saying, there's a lawyer here, Tyler Pollock, and he has a question about an ex parte order. What would you like to do, Judge? Would that how hard could that be? Well, it wouldn't. It would be
No.
simple. It would be the simplest little thing that would allow the judge, if he or she wanted, to say, I'm sorry, Mr. Pollock, but I can't hear you today. And better yet, but I'll tell you what, I will hear you tomorrow. Or if you contact Madam Clerk, I will direct her to find you a judge to speak to tomorrow. That would have been relatively simple from my perspective, and it seemed to be a little too much, at least in the Judicial District of Calgary, or Judicial Center now.
Mm-hmm.
You know, and so I wanted an opportunity to talk about this, both because I know it frustrated you, but it's just a microcosm of the problems that we've been having with justice, where I think we have needless bureaucracy and complexity that ultimately destroys our capacity to deliver justice to most Canadians. And it's interesting in British Columbia, and they don't have family law, but I was online yesterday talking to some lawyers, a guy named Jordan Furlong, who's quite well known in Canada, about innovation and justice, and made a comment about some conversation I had with Noel Semple, who's a professor at the University of Windsor. And they brought to my attention in British Columbia, there's a new civil justice program, and it's very streamlined, and it's designed to allow people without lawyers to function fairly well. And it's almost like Judge Judy, but sort of online, where what's your problem? Tell me what it is. We'll send, this to the other person. They'll tell me what their response is, and we'll give you a written decision. And charge a little fee, but and I think it matters. I think it's under $5,000, and also dealing with minor motor vehicle accident injury claims.
Oh, wow.
But it doesn't have to be this complicated. It doesn't have to be fill this form, that form out in quadruplicate and provide this, that, and the other thing. It can be quite simple. But for some reason, bureaucracy loves to create more bureaucracy. And the cynics that watch this, non-lawyers in particular, they go, well, it's to keep people out, right? There's a method to this madness, which is they don't want people in the system that aren't professionals. They don't want non-lawyers. They don't want people functioning in a place that's restricted for the chosen few, like you and me, and the clerks and the judges. And that strikes me as fundamentally wrong, that we should simplify our system so that people can get there. Now, the law is complex. You don't go to law school and then article and write bar exams because it's easy. And even if it's simple to get in, the odds are 9 times out of 10 in an argument between a competent lawyer and somebody who's not a lawyer, the non-lawyer is going to lose. But at least they have the opportunity to be there. And what happened in your case is so offensive, in my opinion, because there was this indifference to the reality of a serious potential problem. So what are you doing about that? You writing a letter? Have you made a complaint? What's the...
Yeah, I haven't quite decided. I've been pretty busy, and I haven't quite decided how to handle it. I think it is something that, I think it's my duty to follow up with this and make sure something is heard, at least. Whether something can be done or not, I don't know, but it should be heard. So, yeah, I guess I could contact the clerk's manager or supervisor up there and say, look, here's the issue I'm facing. And I'm sure that person is, under a lot of stress about administering things, especially as things are changing so rapidly in all our court systems, being virtual and things like that. So they'll be frustrated. And I'm sure that they hear lots of complaints about issues with administration. So I guess that's one route to go. This is another route. Talking more with other media could be another route. Yeah, I don't know yet.
In fairness to even these clerks, and county clerks have been notoriously difficult, but even in fairness, one of the struggles of the provincial court generally is they're very procedurally bound because they have no inherent jurisdiction. It's all statutory, and to people that aren't lawyers, that maybe doesn't make a lot of sense, but one of the struggles is that if the act and the statute doesn't say this is how you do it, there's this sense we can't do it that way.
And most of the acts and statutes say, here's the form, here's this form, and here's what can be done, and here's the 3 remedies. And it's that's right, provincial court limited in that sense. Whereas this Court of Queen's Bench, we say, has inherent jurisdiction. They can sort of deal with everything inherently. They can grant justice inherently. So I can appreciate the limitations, but.
Curious. I recall a few years back, I was fortunate to go to Betty Ford with a group of judges and lawyers for about a week to gain greater understanding about addiction and cycles of addiction and that sort of thing. And there were some provincial court judges there, in particular Judge Fisher from Medicine Hat. And we got into this discussion, and I expressed my frustration with provincial court compared to Court of Queen's Bench. And he said, well, why wouldn't you go to provincial court? I said, because it's harder and it takes more time. And at the end, it's probably more expensive for my clients. And he seemed all like incredulous. And I said, well, here's an example, Judge Fisher. I said, in Court of Queen's Bench, if I have a consent order agreed to between me and the other lawyer, interim support, something, the 2 of us can sign that order. I can walk into chambers on a Tuesday morning or a Wednesday morning, and it takes me 5 minutes. I explain it to a judge, and they sign the order, and you're done. You can't do that in provincial court. I said, in provincial court, if there's a negotiation on an interim basis and you come to some resolution, you can't walk into court with a consent order. You got to file a formal application. You got to provide reasonable notice, and you got to set it down for a week. And then you got to wait and come into court and wait till your matter gets called. And I said, just that is more expensive and more time consuming.
Now, what a minor example, but that's exactly right. Imagine the costs, and I got to draft an application, and you can't do it half-assed, right? Like, you got to make sure you're doing a good job, because what if the consent order follows through? You got to make sure the application's drafted well. So, you're putting maybe an hour, maybe 2, whatever it is, into that. Yeah, you got to serve it. You got to make sure you probably have an affidavit of service to be able to show that all the steps have been taken, and then you got to go and show up.
Talk to the clerks, in fairness, and I've had these conversations with provincial clerks. They say, well, I don't have the file. So when you come into court with a consent order, I don't know what's going on because I can't make an endorsement. So they make notes on everything that happens with the files, right? No, there was an order granted, blah, 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 particularly because they deal with a lot of non-lawyers in provincial court. Mm-hmm. But yet, reams of self-represented parties in Court of Queen's Bench now, they have the same issue. You walk in with a consent order, there's no file there. So I don't really understand completely the rationale for why provincial court has to be as
cumbersome, perhaps.
Cumbersome, when it's supposed to be a simpler level of court.
More easily accessible is what it's supposed to be. Yeah. I find the opposite. Yeah, you're right. Typically.
I haven't filed a provincial court application in 20 years.
I haven't filed one in a very long time, yeah.
I don't like the judges or the clerks.
No.
It's a more cumbersome place to go, and it is more difficult to get from A to B in provincial court than it is in the Court of Queen's Bench, which is completely counterintuitive.
Now, I should say this, in fairness, that I did, in about 2016 or so, work with some of at least one judge that I can recall, and some of the clerks in provincial court here in Lethbridge, and there was some streamlining of some processes that was within their ability and control. So again, that's an example of how our clerks have been really good to work with, and they have been able to do stuff. And what I'm speaking of in particular is a few things. One is, you used to show up and they would just start calling all the matters in order of seniority. And if I'm sitting there and I have to talk for 1 minute to adjourn something or to enter a consent order or whatever, I just need a minute. Sometimes I'd have to wait 3 or 4 hours to get through all of. And so then they started doing this. I had made the suggestion, and maybe others had as well. And the court took it really well, and they said, okay, yeah, we'll deal with adjournments first. And that's been just a fantastic change. So I know that's one thing.
When did you do this?
It was about 2016. I actually think I still have the letter from the judge somewhere where he says, yeah, I'd be happy to facilitate that. That's a great idea. And I remember I would bring it with me to court on occasion in case they didn't do it first, then I'd be able to pipe up and say, hold on a second.
So
We're
the
supposed to.
irony is they've been doing that in the Court of Queen's Bench since I articled in 1985. So think about that, right? The simplest little thing that helps move things along, they didn't figure out that that might be beneficial
Till
for
2016.
31 years. Like it boggles the mind. And you know, it struck me. I'm a bit of a Twitter hound. One of the things I saw today, a young woman, Chelsea Rogers, at Chelsea Rogers 95. And I'm just going through Twitter and being angry at the throngs of people who hate each other because they're right or left or whatever. And she tweeted this morning, "Today is my first day of law school." And I get really cynical and I get bitchy about what I do sometimes. And she's so excited. And I remember my first day of law school and how both intimidating and exciting it was. And the comment I made to her was, best of luck, be curious, and always challenge conventional wisdom. Creative thought will seldom come from the bench, from law societies, or lawyers in practice. And what you've told me is just that, right? That the legal system, worse than perhaps every other system, it just struggles against innovation and it resists change, even when it's for its own benefit. And I think, you know, and you're a younger lawyer, obviously, than I am, and this young woman is younger yet. She's just 1L. But you know, when I talk to young lawyers, just that. Try not to lose your imagination, because this system will beat it out of you if you let it, right? There is an inertia, a conventional wisdom that permeates what we do as lawyers in the worst kind of way that stifles anything that looks like innovation or consideration of new and better ways of doing things. So.
And we've talked about this a lot. It's not just the bureaucracy of the court system. It's law firms and lawyers. It's the government. It's sending me letters. It's attaching a letter to an email and sending it to me. It's, old-fashioned systems. It's paper files.
But it's like this. This is the analogy that struck me. You go in the lunchroom when you're in high school, right? And everybody is on their best behavior not to stick out, because they need to be popular with the cool kids, because kids are so damned cruel for those that are different or odd or unique. And the practice of law is really like a shitty lunchroom in a crappy high school somewhere, where, you know, let's just all be conventional. Let's not stick out too much. I mean, we'll make the arguments, you know, and once in a while, you know, we'll raise our voice a little bit. But for the most part, you know, there's this clubbishness in what we do, where it's much safer to toe the line and to not do what you did, and certainly not do what we're doing now. But the problem with that is you end up with the emperor wearing no clothes for 300 or 400 years, and nobody's got the guts to say, this mother's naked. Because for them to do that risks expulsion from the tribe. And the tribe is the lawyers and the law societies and the judges, right? And I think we don't acknowledge that to the extent we should. And so I think what you did is quite exceptional. It's to be congratulated. I was quite proud of you for standing up for your client and sending a message, particularly to young Aboriginal man, that as a Caucasian person, we give a shit, right? That we're not about to put our interests in being popular with the cool kids in the lunchroom ahead of doing our job, which is fighting, within the bounds of ethics for our clients. So I appreciate you doing that and sharing that.
Well, thanks. I can say, the client was happy with the outcome, and I know that the clerks here in town, when I went to go file the order that we got as a result of the appearance in the higher court, the clerks were pleased that I'd done what I did, and I put them to a bit of extra work in a couple of days, and they were happy to do it and happy to help as far as administering justice goes. So thanks to them too.
Well, good. So anyway, that's, I pontificate a little bit there. But I sincerely, it's been a while since I put my neck out there like you did today or this week. So that's good. That's
yeah, there's a few clerks who don't like me, and I guess it makes no never mind to me, especially considering, it was unfortunate, but I didn't need them to go about getting the result that was necessary. And hopefully the judge doesn't that granted the original order doesn't take any offense. I can appreciate that that's a tough role to be in, and you're getting bombarded with facts and who knows and long lists.
Oh, but it's not as if for a moment we've said today, well, that judge was completely inappropriate. I mean, I have some concerns about that order.
Yes.
But, the judge did what they apparently thought was the right thing to do at that moment.
It was the administration. It was those clerks that barred me from accessing justice that was the problem, to be clear.
Yeah. So, we've been on,
there you go.
I don't know, 2:45. So probably 40 minutes or so.
All right, well, let's leave everybody alone.
Plenty. Any plans for the weekend?
I got to work. I'm behind 2 days now because I was dealing with this so extensively, so I got to catch up.
Yeah, I have, what do I have going on? Nothing major. I got an application I got to deal with. Filing some documents, speaking of which, that's probably going to occupy some time this weekend, but got a real estate deal that my clients want to meet with me on Sunday, and it doesn't look like that's going to work, but
not too bad.
No rest for the wicked. Probably.
Yeah. Sometimes we take a little break, but not this weekend. Yeah.
I will be playing some Call of Duty. So if anybody's playing Modern Warfare, look for Sergeant Rock with 2 R's, RROCK. And if during the game you have some legal questions, throw them at me.
Sounds good.
All right. Well, you have a good weekend.
All right, you too. Goodbye, everybody.
Bye.